and the judges can introduce themselves.
Thank you. Congratulations, Illinois. Welcome to the National We the People competition. This is the first team that we've seen today where all of the students are gathered together in one place, but we're glad to see you and we look forward to your presentation. We're going to introduce ourselves, ask you to introduce yourselves, then hear your opening statement. Excuse me, before that, I will read the question, then we'll hear your opening statement, provide a chance to ask you some questions and conclude with some feedback. My name is Dan Taubman. I'm a senior judge on the Colorado Court of Appeals in Denver, Colorado.
My name is Ali Khan. I'm an attorney in Chicago and alum of the program representing Illinois in 1998.
And my name is Ben Glickman. I'm also an alumnus of the program. I represented California at the national finals back in 1995. In my day job, I work for the California Attorney General's office.
Would you like to introduce yourselves and your teacher to us, please?
Hi, we're Unit 3 from Maine South High School. Our esteemed coaches are Andrew Trankel and Kevin C. Hansen. I'm Anna Wapner.
I'm Nikki Manolis.
I'm Drew Burgess.
I'm Sydney Lucas.
And I'm Gabby Gavetsky. Thank you for being here with us today.
Well, welcome again. We're going to ask you about question 1, which I will now read. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin.
It is emphatically the province and duty of the Judicial Department to say what the law is. Justice Marshall recognized the importance of the judicial branch within our federal government. The Supreme Court's ability to practice judicial review is a vital function that serves to maintain and advance the democratic values enumerated in our Constitution.
In times of uncertainty, judicial review can mean the difference between revolution and unity. Originally intended to serve as a check, judicial review is now a tool for extending civil liberties and rights to the states as allotted through federalism, as well as protecting the people against unconstitutional infringements.
The ruling of the 1803 Marbury v. Madison case established the practice of judicial review, which is further supported by Article 6, Clause 2 within our Constitution, also known as the Supremacy Clause. By establishing the federal government's power, specifically that of the Supreme Court over the states, the relationship between the practice of judicial review and federalism is showcased.
Despite the sovereignty of the states, the laws that govern them must remain within the bounds of our Constitution. This was enforced in several Marshall Court decisions, such as Cohen's v. Virginia, hence the profound impact of the significant Marshall Court rulings and the resulting practice of judicial review on federalism.
Following the Civil War, the 14th Amendment Equal Protection Clause greatly impacted judicial review. Courts utilized the Equal Protection Clause to ensure that no state denies, quote, to any person within its jurisdiction the equal protection of the laws, end quote, which has been vital in cases such as Brown v. Board, Loving v. Virginia, Roe v. Wade, Obergefell v. Hodges, and more.
Judicial review strengthens the nation by providing consistency, unity, justice, regulations, and equality across all states. Additionally, procedural due process, guaranteed by the due process clauses in the 5th and 14th Amendments, requires government officials to act in certain ways before they regulate or take life, liberty, or property. Substantive due process, also ensured by the due process clause, allows the courts to protect civil liberties and rights, including those not explicitly enumerated in the Constitution, from government infringement and ultimately tyranny.
Though judicial review was created to be able to counter the majority, it is no way an illegitimate procedure that endangers our democracy. Supreme Court justices are not elected or re-elected. Consequently, they remain persistent in their interpretation of the Constitution. This consistency in their interpretive ideologies counters the claim that the institution's invalidity is because judges make decisions based upon their personal beliefs.
President Taft once said that, quote, presidents come and go, but the Supreme Court goes on forever, implying that courts, though equal in power to all other branches, leave a much deeper and lasting mark on our nation. However, it is also important to note that the majority view in a certain area, such as a municipality or a state, may not be the same stance as the majority of the nation. Therefore, the Supreme Court can actually uphold the democratic ideals of majority rule when they declare an act unconstitutional.
The system of checks and balances within our federal government serves to maintain a balance of power among the branches, with the practice of judicial review having the ability to be checked. The Constitution's Article 3, Section 2, court jurisdiction, as well as Congress's power to pass amendments such as the 16th and 11th Amendments, are examples of these crucial checks on the court. Among the already existing limits placed upon the court, there is certainly room for more checks, including but not limited to term limits.
James Madison once said that, quote, all men having power ought to be mistrusted, end quote. The practice of judicial review and the system of checks and balances within our country exemplify this idea, acknowledging that mistakes within our government are inevitable. Nevertheless, it is the duty and responsibility of our leaders across all branches and levels of government to continuously protect the integrity of the Constitution, the nation, and most importantly, the people. Thank you. We are now open for questions.
Thank you very much for your opening statement. In your opening statement, you mentioned that judges decide based on interpretive ideologies and based on their personal beliefs. Do you think that judges decide based on their political views or based on judicial philosophies or something else?
Judges certainly aim to look at court cases from a constitutional perspective. I think political beliefs need to be left outside of the courtroom, and I think that they are. I think we've seen this with our current Supreme Court, with recent nominees, President Trump going against his attempts to have recounts for the election. I think this just shows that they go by the Constitution and stick to their interpretive ideologies as opposed to referring to their political beliefs.
I think in our speech, we mentioned this sense of consistency within judges' interpretations. For example, Justice Scalia he reviews cases with the originalist method, and he uses this consistently in all his rulings, which provides predictability and consistency in his rulings, which ensures this protection, which is what we were saying avoids them essentially just making decisions on their own agendas because they're consistent and we can predict what they're going to say.
I absolutely agree with my colleagues. In fact, in a study of the 2019 term done by Harvard Law Review, it found that Chief Justice Roberts found himself in a 5-4 majority with every other justice. However, when you compare Justice Roberts and Justice Alito, you find that they only aligned in one 5-4 majority, representing the consistency that they show in their own interpretations of the Constitution, countering the argument that the institution's invalidity is because judges make decisions based on opinion.
Well, I mean, is that what it shows? Or does it just show that they're consistently political? Like, I don't understand how the fact that Justice Alito is always going to rule in favor of religion, or Justice Gorsuch is always going to favor in religion, how that shows that they're apolitical. It just shows that they're consistent in their political views. So I guess another way of asking this is, isn't a political philosophy just the manifestation of a judge's political views?
Personally, I would agree with your statement and disagree with my colleagues. This would just be because everyone is swayed by their personal opinions, and the way that these judges got into office was because of their opinions kind of matching up with the president that appointed them. But I do see the validity of all my colleagues' statements, considering that this consistency just kind of depoliticizes the court in a sense, because we as a people, when they are appointed, we know how they're going to react to certain cases.
Adding on to my colleague's statement, I also agree that judges may have a little bit of a political bias, but when it comes down to it, they will rule in favor of the Constitution. In Federalist 78, Hamilton wrote that when the legislature stands in opposition to the will of the people as written in the Constitution, the judicial court, the Supreme Court, will rule in favor of the latter, which is they'll rule with the fundamental law, not the non-fundamental laws. And I think this really establishes the point that while they may have political bias, their first and foremost duty is to protect the ideals of the Constitution. And so even when a personal ideology may conflict with that, it's their role to support the ideals of the Constitution. And although it really hasn't been used, we do have the good behavior clause in Article 3, where it says that judges may remain on the court when in good behavior. And although only one justice has ever even been impeached and not removed, there is this kind of line of defense where if they're not acting in the best interest of the Constitution, then they may be removed.
In your guys' speech, you mentioned that term limits being a potential restriction on the judiciary. How do you feel about term limits for Supreme Court justices? Do you support them or do you not support it? And either way, why or why not?
Yes, we absolutely support term limits. I, for one, am a proponent of an 18-year term limit, and Chief Justice John Roberts was also a proponent of this. He said, quote, that not an 18-year term limit, but he said that, quote, setting a term of, say, 15 years would avoid decades of ivory tower existence, in which he's kind of mentioning this idea that judges are serving now an average of 28 years, which is more than it has ever been in American history. And their intellectual primes are decaying through this time. And I think it's hard for us to trust justices who have been on the court for so long. And similarly, justices can kind of stay on the court until they see a president come into office that they politically align with. And I think as times are changing and our society is evolving, we can't trust a judge that is serving for 30 years when our society is constantly changing and we need the Constitution to reflect those changes.
How did you land on 18 years?
Well, 18 years, we would have a cycle in which these 18 years.
But why 18 years? How did you pick that number?
So with the 18 years, there would be like a staggered system in which every re-election there would be a new set of justices, because they would serve the 18 years, and then with the new election it would stagger and you would have a new set of judges coming into office.
No, right. I understand that. I guess what I'm asking, to be more clear, why 18 years as opposed to 10 or 30? You know, how is 18 the sweet spot for this term length?
Well, I think it's important to note that Supreme Court justices will always leave a legacy, but in order to do that, they really do need a good amount of time on the Supreme Court, because the Supreme Court doesn't really hear that many cases every year, right? So in order to really have a lasting legacy and in order to really represent, you know, the will of the people, it would be important to have them for a long amount of time. I think 18 years, although perhaps that seems like a random number, I think that it's a great number because it gives them a perfect amount of time to make some really significant rulings, but it wouldn't really overextend their stay. But like Nikki mentioned in the quote, you know, some people may advocate for 15. Nevertheless, it's still, you know, 10 plus years allotting for significant changes to be made.
I'd like to switch gears and ask you how the doctrine of selective incorporation has affected judicial review and the principle of federalism.
So incorporation is really interesting because it highlights the system of federalism, because before the ratification of the 14th Amendment and the Due Process Clause, and as well as before the Placo v. versus Connecticut case, the states were not obliged to apply the Bill of Rights to their citizens. So after the ratification of this reconstructive amendment and after the ruling of this case, Supreme Courts were able to incorporate either fully or selectively, which was established by Placo v. Connecticut, certain aspects of amendments. So for example, like the First Amendment is fully incorporated, whereas the Fifth and Sixth are partially incorporated, but still there are some amendments that haven't been incorporated at all, like the Third.
Okay, thank you. Your time is up. Thank you very much. Let's show our appreciation for the team.
Now the judges have follow-up.
I'd like to start by sharing a few comments. Excuse me. I thought you had a lot of good information in your opening statement. You had cited some initial cases like Marbury and Combs versus Virginia, where the judicial review was exercised And then you mentioned with the equal protection and due process clauses, you mentioned for equal protection, Brown, Loving, and Obergefell, but you didn't really tie them in as you might have to the last question I asked, which was about selective incorporation, about how that enabled the Supreme Court to review actions of the states under the doctrine of selective incorporation. Although I was impressed that when I asked you about selective incorporation, you were familiar with it and you realized that it's been partial and not complete. And so that was very good. I was impressed in your answer to one question where you were talking about Justice Scalia and his originalist interpretation. We haven't heard that from any team yet, but that's an important view. And the whole question of whether judges decide cases based on their political views or their judicial philosophies is one that we could debate all day. I mean, people have discussed that about whether judges have judicial philosophies that lead them to decide a certain cases a certain way, or whether they're just, if you read the newspapers, they always say, well, the Republican judges decided this way and the Democratic judges decided the other way, or vice versa. So that's an important discussion to have, not only today but to continue, because it's worth pursuing. I was interested in saying that you think that judges should be term limited to 28 years, and that some of them have had their mental facilities decreased. You might have mentioned that Justice William Douglas seemed to have that happen to him before he left the court, as one example. But on the other hand, there are justices like Justice Ginsburg, who passed away recently, but nobody thought that her mental faculties had diminished, even though she was well into her 80s when she passed away. But overall, I think you did a very nice job, and congratulations.
Go ahead, Ben.
I'll go. I thought I would echo everything that was said. I thought you did a nice job on the prepared remarks. The one thing I would suggest, the one constructive piece is it wasn't always apparent to me which part of the question you were answering. And so one thing that's helpful on this side of the table is if you kind of use like signposts or strong topic sentences so that we know, just clearly, yes, judicial review is counter majoritarian. And then I know, okay, they're going to be talking about that part of the question. That's just helpful. We hear a lot of these, and it's helpful for me to listen and to be able to hear that. On the questions, I mean, I thought we had a good conversation. It's hard, right? This notion of political views versus judicial philosophy. Is there really a distinction between the two? Does consistency, does that just show that they're adhering to a neutral philosophy, or does it just show that they're consistently political? Like, I don't know. I mean, Justice Scalia was certainly consistent in applying the originalist philosophy, but many people would say that originalism is just, arrogance masquerading as humility, right? That it's just like a way for them to decide however they want, but justify it by referring to some, 300-year-old dictionary. And so I think I wish we could have talked a lot more, is what I'm saying on that particular question. On the 18-year term limits, I thought I liked your answer. I think one of you was getting to this, the notion that you would stagger them every 2 years, and with 9 justices, that would mean that every presidency would get 2 appointments, and that would theoretically depoliticize the appointment process, because you would know no matter what, the president was going to get 2 appointments, and it would reduce the gamesmanship of timing retirements and things of that nature. So yeah, I thought it was a good conversation, and congratulations again, and best of luck the rest of the weekend.
Well, again, congratulations. And I think my colleagues have covered everything that I wanted to say. So let me add a couple brief pointers. I think you guys did a great job of just, everyone participating, disagreeing with each other when you felt fit. And with regard to the question I asked about term limits, I really appreciated that you had you thought it through. You had some thought process behind it. You had 18 years, but you had some principles behind it. That didn't have to be 18, it could be 15, but here's why it's a sweet spot, right? Where it's long enough to have a legacy and have an accomplishment, but also not too long, perhaps whether you get too much in the ivory tower of being in the ivory tower of being in the judicial branch, or whether you lose your faculties, or whether you're just out of touch. And again, it doesn't happen to everybody, but you're creating a system that you can apply to to a lot of people, not on a case-by-case basis. So I like the fact you thought it through and were thinking on your feet with that. So I think that was a really great job. And other than that, I think you did a great job. And so, congratulations again for being here.
Thank you again for your presentation. We really appreciate it. And we wish you luck during the rest of the competition.